medical decisions. They don't have the authority when they're 17 and a half to make decisions about where to live and educational decisions. When they're 18, the law says that they do have those rights, and guardianship just resets the clock as if they were 17 and a half. In addition to being able to basically losing the right to make their own decisions, medical decisions, and about decisions about where to live, persons under a guardianship will also lose the right to drive and the right to vote, although those are two rights that I can often ask the court to allow a person to retain, especially if they're capable of casting an independent vote, they're interested in voting. Sometimes young men and women are, or if they are driving or they really want like to drive in the future, like to preserve that for the future. The other rights that they lose are the right to own a firearm, the right to marry without the guardian's permission, the right to sign a contract. I think that's it. One thing to think about with these rights, though, too, especially like the right to drive and the right to vote, is, well, like, let's use the right to drive. Sometimes I'm not successful. In fact, most of the time I'm not successful when I ask the court to allow a young man or woman to retain that right, because they're not usually ready when they're turning 18. But when they are a few years later, they can be ready. And so those rights can be restored. It is possible. Once a guardianship's in place, it's not set in stone. You can be modified at any time. You can restore rights, and you can actually even restore all of a person's rights. Did that once for a young woman in Danville. When she was 18, she needed a guardianship. I wasn't doing this work then. But when I met her and when she was in her early 30s, she no longer needed a guardianship. She was pretty much making all of her own decisions, making her own doctor's appointments, getting to and from her part-time work, pretty much all by herself. So we were able to restore all of her rights. So that's a guardianship in a nutshell. It's over the person, so to speak, but it's not over finances. That's a conservatorship in Virginia. It's the same process as a guardianship, but I don't recommend it in most cases for a couple reasons. One is usually a young adult has no estate to require a conservator to manage. When they become eligible for SSI, and we'll talk about this in a bit, you can become their representative payee, which means their checks will come in your name for their benefit. You'll open up an account in your name for their benefit, and you'll have control over their primary source of income without a conservatorship. In fact, the Social Security Administration doesn't use conservatorships or powers of attorney because those are creatures of state law, and Social Security Administration is a federal part of the federal government, so they use the representative payee program. And finally, another reason not to do conservatorship is they'll come with reportings to the Commissioner of Accounts. It's like being an endless probate, and those reportings can be less frequent, and they'll be less expensive for Medicaid recipients. But if you forget the first time you get a notice, it comes with a fine for being late. So it just doesn't make sense to do it. The only time I do conservatorships is if a young man or any person who relies on SSI, Medicaid waiver services, if they get a direct inheritance or if they get some money in some fashion. And we've got to then move that money to restore their eligibility for those benefits. So I said the other avenue of approach is to do a powers of attorney and advance directive. These are documents that a person can sign to appoint agents on their behalf. And they're really very similar, almost the same as the documents that we tend to do with estate planning. So there's a durable general power of attorney. It's very useful. It's got all these different things you can do with it. For finances, paying bills, opening accounts, for Medicaid applications, it covers like going to signing for services for Medicaid waiver services. That's technically a contract. And all these different things that you'd be able to do as an agent for your son or daughter if they sign one of these. I found, like, my daughter's aunt has one, she's 23, and I found we've never used it. It has all these wonderful things that you can do with it. It's nice to have in the back pocket, but since part of our job and part of our goals for parents is to help our children learn to do things for themselves. All those things that I just talked about are things that we do with our daughter and have her do it. And so she's able to understand it. And the more she does it, the more she understands it. So it's a very, I don't want to say powerful. It's a very useful document, but we don't use it very often. And I have very few clients that actually use it as well. That's the feedback I get. They're right. Yeah, use like, we just do it with our son because, that's what we're trying to do. And so the Advanced Directive for Healthcare, which is basically a medical power of attorney, on the other hand, is very useful. Um, when a young man or woman turns 18, you can try calling doctor to set up an appointment. You're most likely going to get some feedback from them, pushback saying your son or daughter's 18 now, and we really need to speak to them. We have a son who's typically developing. He's 21 now, and that was exactly what we experienced with him. Our daughter, on the other hand, having an advanced directive on file with the doctor allows us to make appointments for her, fill the prescriptions, talk to the doctors talk to us. It's almost as if it's your child is 17 and a half again. Now, they don't lose the right to make their own decisions, though. So doctors really should be talking to your son or daughter, even though they have an advanced directive on file, so that your son or daughter can make the decision. But if they need help making the decision, you can definitely be there to help them make that decision. There's also a power of attorney for education, which is for IEP meetings. It's for actions under the Individuals Disability Education Act, and it ends once your son or daughter leaves high school, either through graduation or aging out at age 22. So it's got a limited time window of usefulness there. And really, an alternative to a conservatorship is a representative payee. I've got it listed here as an alternative to a guardianship, but it's more of an alternative to a conservatorship. Now, comparing the two approaches, first of all, the first thing when I talk to families, I learn more about their son or daughter, their challenges, their successes, their abilities, things that they need help with. And we kind of I get to a place where I can give advice as to which way is the better way to go. And the first thing I want to look for is whether or not I think that the young man or woman has the capacity to sign the powers of attorney advance directives. It's a legal question whether or not they have that capacity. So it's up to every attorney to determine that for themselves. If we feel ethically, we're supposed to, if we don't feel that somebody has the capacity to sign a particular document, that we shouldn't have them sign it. So since I worked pretty much solely with persons with disabilities, I like to find that capacity where I can. So for me, it's enough that when I'm talking to your son or daughter and we're discussing the documents, they don't have to be able to read it. They don't have to be able to recite it back to me. They don't even have to really tell me what it does. They just need to understand that they're allowing their parents, by signing the document, to continue to act and do all the things that they have been doing as their agents. And in many cases, it's enough for me if I ask them, do you want mom and dad to be able to continue making decisions for yourself, or who do you want? And they point to mom and dad. So, but that's not the end of it. Just because they may have the legal authority, in my opinion, to sign a power of attorney advance directive, that doesn't necessarily mean that's the end of the discussion. And I can point to a number of cases, clients who I believe have the capacity to sign a power of attorney advance directive, but we went with a guardianship instead. First one that comes to mind is a young woman with Down syndrome who had 4 heart surgeries and had been talking about not wanting to ever go back to a hospital. She hates them. And it scared her parents to death that they would be relying on an advance directive, which allows their son or their daughter, in this case, to continue to make the medical decisions. And they'd have to be trying to convince the doctor that she wasn't making, or she wasn't actually being able to make a good decision at that time. So we went with the guardianship, because a guardianship's clear cut. Under a guardianship, it's the guardian that makes the decision or signs the paperwork and so forth. doesn't mean that you change how you interact with your child. The interactions are all the same, no matter what you decide to do. If you're at the doctor's, you're still going to be talking to your son or daughter, and the doctor is too, to get them to understand what's going on as best as they can. It's just at the end of when the time comes to sign that form consenting to the medical procedure, it'll be the guardian's decision and the guardian's signature that's operative. Under an advance directive, if your child, since they don't lose the right to make their own decisions, the doctor, after explaining everything, believes your son or daughter has understanding enough to give informed consent, well, then your son or daughter will make the decision. If they need help to get there and you're there and helping, that's great. The problem comes in with an advance directive, though, is when your son or daughter says no, and doctor says, well, we really need to do this, and you're like, we really need to do this. And at that point, it's less likely that the doctors can provide that particular medical treatment over and above your son or daughter's no. That's where a guardianship is a little bit. So we try to avoid those situations. So another situation where I've done a guardianship instead of an advance directive is when a young man or woman is so, what's the right word for it? I don't want to say scared, but of needles, of getting blood drawn, of anything like that, where they have to be actually sedated. And so even the act of sedating somebody who's not willing to do something is probably problematic for the doctor under an advance directive. Under a guardianship, it's not. It's just like if they're a child, you talk them into it. You're not doing this, you're not forcing them in, but there are some young men and women with disabilities that will absolutely refuse to do those kind of things. So in those cases, a guardianship would be appropriate. And a couple times we've done it for behavioral issues, where a young man or woman on the autism spectrum will sometimes lash out when they're overstimulated or when they're frustrated. And those behaviors, and most of them start to, they diminish over time. But when they turn 18, those kind of activities can actually get you into quite a bit of trouble if you end up injuring somebody or injuring property, or somebody feels threatened, and then the police are involved. And the belief, the understanding, the expectation is that the police, the Commonwealth's attorney, will treat the situation differently if the young man and woman's under a guardianship already. So in a couple of cases, we've done guardianships for that purpose as well. So it's a complicated decision in many cases, especially if a young man or woman is fairly high functioning. But I kind of been hitting a negative tone here, a note, and I don't know why. So what I would say is that it's always better to work with the least restrictive option first. So for many high functioning young men and women, we do the power of attorney and the advance directive, and they work wonderfully. And in fact, I can tell you that I have had no clients come back and say, this advance directive and durable power of attorney approach is not working for us, we need to do a guardianship. So if a young man or woman has the capacity to sign those documents and doesn't have any other medical issues and concerns like that, then that would be a good way to go. I'm saying this now because I don't want to make it sound like I'm like, oh, we got to do guardianship. It's all, it's so straightforward. So I got these questions here, but I'm going to continue to go, and if that's okay with everybody, and I'll just get to the questions. I see the chat room filling up with questions, and I'll do that when we get to the end. So in addition to having to make a decision about what's the best way to support your son or daughter capacity, decision-making wise, when they turn 18, they're likely first time eligible for disability benefits. And there's a couple here that I want to talk about. The first being supplemental security income. But we'll also talk about Social Security disability insurance, childhood disability benefits, and then a couple medical benefits. Um, so SSI is a federal benefit. It's meant to pay for room and board. It's for persons with disabilities that are or over the age of 65 or blind persons that have low income and low assets. Income limit for a young man or woman is never an issue. So let's focus on the countable resource limit here. It's $2,000. One of the reasons why a child under the age of 18 is likely not eligible for SSI is because the parents' income and assets are deemed to be the child's. So if the parents have more than $2,000 accountable resource, the child won't get SSI. But parental deeming of income and assets ends when a child turns 18. So it's just their income and their assets. So that's my advice would be to apply for SSI for your son or daughter after he or she turns 18. There's no reason to do it before you turn 18. In fact, the Social Security Administration is really not set up to do that. If you try to do it prior to the age of 18, that's going to start asking for your income and your assets because of the parental deeming issue. But if you start right after they turn 18, then it's not an issue. And even if you were able, I've had a couple clients prior to COVID, now that's saying something, be able to file it early, but it just messed everything up because you have to trick the system with the income and the assets and all that. So the other thing to consider is that from the date you apply to the date of the first check, your son or daughter will get a back benefit check. So if it takes the Social Security Administration 4 months, they'll still get benefits for those 4 months. So there's really no reason to try to do it before they turn 18. My advice on applying for SSI is the easiest way to do it, especially now, is to do it online. You can create a password and you can fill out portions of the application, which is basically looking for doctors and hospital names and phone numbers and addresses and schools and so forth. There's a lot of information there. But to do it online, you can create a password, fill out parts of it, and save your work, come back and fill it out the rest of it. So what happens once the Social Security Administration, the local office, gets your application online is they first look to make sure your son or daughter, the applicant, meets the income and asset limits. And if they do, then they'll send out requests to all the entities that you list in the application. And so you don't have to supply the records either. Social Security Administration gets that. Once they get them all, they send them to Disability Determination Services, who looks at the medical records and decides whether or not your son or daughter is a person with a disability. So SSI max benefit in 2022 is $841 a month. It's not a lot, and it's meant to pay for room and board. So you probably heard that you want to charge your son or daughter rent once they get SSI. The reason for that is that if they live in the house of another and are not paying their fair share, and that's the word the Social Security or the term the Social Security Administration used, fair share, then they'll lose 1/3 of their benefit. But if you're charging them rent, then they'll get the full benefit. So the way that kind of works is once they're getting the full benefit and you're charging them rent, so you're their representative payee, the SSI checks direct deposited into the representative payee account. And every month then you should either cut yourself a check or do a transfer into your account for the amount of money for the rent. And just recommend you put a little note in there that it's for January rent. It's probably not needed, but just in case. So one of the things that charging them rent does is gets them their full benefit. The other thing it does is it's the largest single draw on the representative payee account every month. Because remember, they have this $2,000 countable resource limit. So that means that that representative payee account can never get over $2,000 at the end of the month. It might reach it when the check is deposited, but by the end of the month, you got to get it under 2,000, or technically your son or daughter won't be eligible for SSI for that month. You don't really, and if that happens, you don't find out they don't, the Social Security Administration doesn't monitor things that closely. It's not going to be like, oh, we saw last month, it was this. No, what happens is 2 years later, when they do an audit, they pull the bank statements for your child's account, and they'll see that, oh, for these 4 months, you were over $2,000 and we overpaid you. You should have gotten zero. So now you owe us this money back. And at that point, you're not much you can do about it. So charging rent gets them the full benefit and is also the largest monthly draw on their representative pay account. So at some point, then in the near future, for many of our children, they actually start working, start making an income. And the point I want to leave you with today, because this isn't really in depth about SSI, is that they'll always make more money working with SSI, even though their earned income will reduce their SSI. It's not a dollar for dollar reduction. It's more like 40 cents on the dollar. That's just my kind of back of the envelope calculation. But they'll always make more money working, even though the SSI is reduced. And I've got a chart here later on. So this is when your child first starts getting SSI. You'll see with that part-time work, this is $800 a month of part-time work. Their SSI is reduced, but they're still making quite a bit more money. Gonna fast forward a few months, for a few years after they've been working. It doesn't take very many years for your son or daughter to build up enough work credits under the Social Security program to start being eligible for SSDI off of their own work record. Now, I wish these acronyms were different. We got SSI. SSI is a federal budget, comes out of the federal budget. It's a type of welfare. SSDI is paid through our payroll taxes, and it's something that you can get if you're disabled and no longer able to do substantial gainful activity. So it's got the same requirements, the disabled requirements, disability requirements as SSI. But once your son or daughter becomes eligible for SSDI on their own work records, it counts as unearned income for SSI. So they don't, unfortunately, get any additional income. All it does is that the more they work, the more their SSI, this part, is replaced by SSDI, this part, with their earned income. But one benefit of that, and we'll talk about that in just a second, is that SSDI then would come with Medicare after 24 months. And it's not means tested, so you won't have to be reporting income anymore. It's got a more reliable funding stream because it's paid through our payroll taxes, and it's really hard for our politicians to screw with it. We get everybody up in arms. If you're going to mess with Social Security, everybody's going to, it needs some changes, but it's harder for them to do. And this is a nugget of information for much later down the road. If your child was disabled before the age of 22 and they're unmarried and they're getting SSI or SSDI or some combination of it, when you retire and start drawing Social Security or become disabled at work and start drawing SSDI, or if you pass away, your son or daughter would become eligible for a childhood disability benefit. Wish it had a better name again. Sometimes they'll be referred to as SSDI off of a parent's work record. That's a better name than childhood disability benefit. But either way, what it is that they draw a disability benefit off of your work record, and since your work record may be more substantial than theirs, it usually wipes out their SSI. Clients that I have, most of them that get this benefit make between $1,400 to $1,800 a month on it. It's not means tested, so their earned income, if they're still making $800 or $1,000 of income through their own part-time work, it doesn't reduce it at all. So eventually they become eligible for this. So we talked about SSI, SSDI, and childhood disability benefit. Let's talk about the medical benefits for a second. Oh, and here you can see on the chart, this is when they're working at the same work, but with the childhood disability benefit. So Medicaid is kind of a partner to SSI. It's for persons that have disability over the age of 65 or blind, have low income and low assets, and the asset limit is again $2,000. And it's not actual medical insurance; it's a payment to help pay for medical expenses. It's nice to have, but Medicare, when your son or daughter, if they become eligible for it, it will become their primary. Medicaid is always a secondary payer for disability benefits for the medical side. And Medicare is good insurance. You know, you can carry your son or daughter by law on your work insurance until they turn 26. And I found that many of those same policies through work, through employers, will allow you to continue to carry a disabled son or daughter past the age of 26. So depending on the situation, you may want to ask your HR department for clarification on that. But once your son or daughter becomes eligible for Medicare, if they're still covered under your work policy, that's the time to really consider dropping them, because Medicare then will be their primary insurance for the rest of their life. Medicaid is backup, and it's good insurance. Most of our seniors rely on it, and it's accepted by a wide variety of doctors. One of the common things with all those disability benefits, the SSI, Medicaid, Medicaid waiver services to be specific, is that they all have a $2,000 accountable resource. If your son or daughter gets a direct inheritance, the first month that they get it, it counts as income, and after that, it counts as accountable resource and makes them ineligible for those benefits. I can fix that, so I'm not here to panic you or anything like that. But the fix has a payback clause in it, meaning that any money left in that particular type of trust has to go back to the state to reimburse it for Medicaid expenses when the beneficiary passes, and there's no getting around that. So the better way to do it is to create a third-party special needs trust while you're living and direct the inheritance that you want to leave to your son or daughter with a disability into that trust. While you're living, the trust really doesn't do anything. You're working, you've got your income, you're helping your son or daughter, you're helping them pay for things, and you're paying for your own expenses, and you're in your retirement. But when you pass, then the inheritance goes into the trust. And the way the trust is funded is typically through your wills and beneficiary designations on like life insurance and IRAs and brokerage accounts. So my daughter has one, and my will and beneficiary designations all say everything to my wife. But if she's no longer living, then half to my son, who's typically developing, and the other half to my daughter's trust, not to her directly. So it never counts as accountable resource for SSI, Medicaid, and Medicaid waiver services, but into the trust. And the successor trustee then manages those funds and uses them to support her quality of life. Trusts can own anything that a person can own, any kind of investment, it can own stocks, bonds, CDs, and you can even own a vehicle or a house. So it may even be part of your answer for what is your son or daughter's long-term living arrangement going to be. If you downsize, for example, into a condo and it's in a great location for your son or daughter and they're living with you, well, you might want to leave the condo to the trust so that your son or daughter can continue to live there. And since the trust then would own the property, the successor trustee manages it, pays for its taxes and insurance and upkeep and all those things, wonderful things that come with home ownership. And then the other thing about a third-party special needs trust is when the beneficiary passes, the assets that are left in the trust stay in the family. They go to whoever you say it does in the trust agreement. So that was just a little bit about trusts, third-party trusts. Oh, two more things on that topic is that anybody can contribute money to a third-party trust except for the beneficiary. So my daughter's trust, anybody's money can go in there except my daughter's. So prior to my in-laws, her grandmother and grandfather wanted to leave all their grandchildren some money. So before they passed, we asked them to update their estate planning, and they did. And so now my daughter's trust, they've passed, unfortunately. My daughter's trust has $30,000 in it, and we're just investing it for her future because we don't need it right now. We're using it. We're not using it. Yes, we're skimming off the top now. We have our own money and we're supporting her, and it's hers. It's in her trust, and it can be used later for her. And the other thing I wanted to say about the estate planning and finances and money is, where does the ABLE account fit into this picture? It's a very useful piece of the puzzle. Now, ABLE account is a 529A account. It's very much like the 529B college savings fund. It's got a $16,000 now annual contribution limit from all sources. That's tied to the annual gift exclusion, gift tax exclusion. The money in an ABLE account does not count as a resource for SSI, Medicaid, Medicaid waiver services. It grows, it can be invested, and it grows tax-free as long as the money is used for qualified disability expenses, just pretty much anything for your son or daughter, including living expenses. And so it's a really good option. Now, it's not necessarily a good option for your money. It does have a payback clause by federal law. Virginia has said that it won't collect that money to the extent federal law allows, but we really don't know how Virginia is going to address that. Are they going to try to collect the money? Was this just a ploy to, to get some goodwill, or do they really mean it, that they're not going to try to? And if they don't collect the money when the beneficiary passes, what is the federal government going to do? My guess is that you don't have to worry about that. I don't think that they will, and I don't think the federal government, but that's just a guess. So your money isn't necessarily the best thing to put into a ABLE account. Your child's money, though, absolutely. When they're working and getting SSI, you'll find that representative payee account continues to grow, even as you try to find more things to spend it on. And that's the time to really consider an ABLE account. It works great as a super savings account for your child's money. Keep their representative payee account under $2,000, and you can then save it and invest it and spend it later for their benefit on larger purposes. Or if you have family members that want to give them money for a gift for Christmas or birthday, just put it in the ABLE account. That way it doesn't count as a resource. So gone through capacity. We've talked about guardianships and the alternatives to guardianship, like powers of attorney and advance directives. Talked about disability benefits, SSI and SSDI particularly, and Medicare and Medicaid. And then we've talked about special needs trusts. So once you've got all that kind of stuff done, am I running into a time issue? Somebody coming up? Okay. That kind of leaves you with just really a couple things to consider to continue working on or planning and thinking about for your son or daughter. One of them is work. If they are able to work, well, you want to try to get them to work as much as possible. My advice is to not push, but not worry about benefits. Allow them to work as much as possible. Explore the ability of working and see how far they can get. Best case, and I do have some clients that have no disability benefit because they've been working at like Costco for 24 years. They get paid some $38,000, $40,000 a year, and they're quite disabled, but they have medical benefits through that. Now that's hard to get, but it is possible. And the other thing that you're left with thinking about is long-term living arrangements. And that really is probably pretty much the hardest one of them all, because you have to understand that and accept that your child is likely going to outlive you. And if you can help transfer them or transition them into a more independent long-term living arrangement while you're living, whether that be sponsored residential or group home or other alternatives, then that's really what you should do, what you should think about doing. So I'm going to go on to questions.
Okay. Matt, we've got
Yes.
a lot of questions that have shown up. Do you want me to just run through the list and let you answer them one at a time?
Actually, what I did is I pulled up the chat and I see
Okay,
that, and I can just go through them. So first
okay,
question, if that's okay with you.
that works for
Okay.
me.
Okay. Is it true that with guardianship, you have to report to the court biannually? It's true that you have to report, but it's an annual report. There's a $5 filing fee that goes with it. It's a 2-page report. It's basically asks, how's your son or daughter doing? Are there any medical changes? Do they still need a guardianship? And it's filed with the local Department of Social Services, who then makes a copy and it finds its way back into the court case, uh, the into the court files. One, circuit court judges have supervisory authority over guardians, and one of the about the quickest way to get in trouble with a circuit court judge would be to not file your reports for long enough that you get flagged on the radar. They're looking at it much more closely now than they did just a few years ago. But I don't have any clients with that issue, and I would personally expect a call from the clerk before anything was on any legal proceeding was started against a guardian that I felt. Okay, so next question is, can anyone gain guardian over an incapacitated person? Yes, anybody can file a petition and anybody can be appointed. It's typically parents, but it's not always parents. I do have several clients who, in fact, I'm meeting with a family tomorrow. And they're elderly, and they're looking for somebody to take over, and it looks like the caregiver is going to become the guardian. So can they do it without the knowledge or consent? In a sense, no. There are notice requirements that the attorneys have to follow. I have to notify other family members. I have to notify. Yeah, so no, it's not possible to do it without anyone's knowledge or consent. And that's another reason the guardian ad litem's there. If I tried to pull a fast one like that, the guardian ad litem comes out and says, well, there's other people. Why didn't you notify them? I've had that happen a couple of times just because somebody forgot to list an elder, didn't think that they had to list one of their other children who was an adult, and find out they're 20 years old now. Well, I've got to notify them. So they're family members that I have to notify. Who determines capacity of the person? That's it's not a straightforward question to answer. So when I'm deciding whether or not a person has the capacity to sign a power of attorney and advance directive, it's me. It's a legal threshold. Do they have the ability to understand the powers that they're giving somebody, and can they effectively communicate that understanding to me? As far as their ability to vote, that's a tougher one. And so the question really becomes, is the person, young man or woman, able to exercise an independent vote? And what I found just through my experience is that in some cases, yes. In many cases, I'm not sure. And but in those most cases, the younger man or woman doesn't really have any interest in voting, and so usually the right to vote isn't something that we do it sometimes, but it's not often. How much does guardianship cost? Well, it depends on the attorneys. Our flat fee for an uncontested guardianship is $1,000, and I know people who'll do it for $1,500. But since we work solely with persons with disabilities, and we've got severely reduced prices in some cases, not severely, artificially reduced prices, because we recognize that it's often very necessary, and if you need it, money shouldn't be an obstacle to getting that particular legal service. Guardianship process takes, for me, about 3 to 4 months from start to finish. The earliest you can file a guardianship petition is 6 months prior to somebody's 18th birthday. So really the best time to start thinking about it and talking to an attorney is about when your son or daughter is 17 and a half. Now, there's no difference in the process whether or not you do it before they turn 18 or after 18. In fact, it's the same process for guardianship of an 85-year-old. In fact, much of the statute, in my opinion, is written with an 85-year-old in mind. So there's really no difference in the process. It takes about 4 months then. if you move to another state, will the guardianship still be effective? And the answer is yes. But what you're supposed to do is if you move to another state, you're supposed to transfer the guardianship. Remember, I said the circuit court has supervisory capacity over guardians. It's a little hard for a court to exercise that if you're in another state. It actually says in the statute, if you're moving to another state, you notify the court here, you find a court in the new state you're moving to accept it. And it's basically through the attorneys, the two courts talk and transfer the case. And it might need a new order in the new state just to comply with their laws, but you shouldn't have to go through the whole process. Guardianships are creatures of state law, so every state's law on guardianship is different. There's a lot of areas of law where that's the case, where every state's different. And all those areas of law, the American Bar Association puts forward some model laws that they suggest states use. And most states use those. Virginia does. And most states that I've helped transfer guardianships to also do. So you don't have to redo it. The only time you'd have to redo a guardianship moving to the other state if the other state doesn't follow the model laws and they don't have anything in place for a transfer from another state. But I don't know of any such state personally. When should we start the guardianship process? Good time to start talking about it again. Like I said, it's like 6 months prior to 18th birthday. And even if you don't want to be doing a guardianship, even if you're thinking power of attorney and advance directive, that's still a good time to start talking to an attorney about it. If you go the power of attorney and advance directive route, your son or daughter can't sign them until they turn 18 because they don't have the legal capacity until they turn 18. But you can always have them in place and ready to go. Can you do a guardianship without an attorney? I don't think so. In Virginia, everything that's done in a circuit court, there are no forms, not like in juvenile and domestic relations. There is no help from clerks. And the attorneys write the orders, the attorneys write the petitions, everything is attorney written. Sometimes I think that's because Virginia attorneys want to try to maintain the business of working in circuit courts. It's also too is that, and I found this to be true when I was putting together my practice, the guardianship statute is unlike any other of the statutes. It has different rules for process, service of process. It has all sorts of little things you got to check off it. Is it conceivable that somebody could read through all that and do it themselves? My answer would be it's conceivable. But I've been practicing this, doing guardianships now for 6 years, and I'm still learning new things. So it's also conceivable that you could get yourself kind of stuck where you're being told you need something else or don't have anything, and then have to hire an attorney to finish it up. But for SSI, if your son or daughter was approved when they were a child, but because your income or assets may have increased and they no longer became eligible, yes, you should apply again once they turn 18. Now, if your son or daughter is already receiving SSI as a child, what happens is the Social Security Administration will send you paperwork to fill out a few months prior to their 18th birthday to do an age 18 redetermination. It's to make sure to verify that your son or daughter meets the adult definition of disabled. So another question is, with SSI, can your son or daughter still hold a part-time job? And absolutely. So the definition of disability for SSI and SSDI is the inability to perform substantial gainful activity. That's a term of art. That's a defined term, substantial gainful activity, SGA. And so it's not saying that they can't work at all. It's saying that they can't perform enough work to meet their basic needs. One measure of SGA is whether or not a person makes more than $1,350 a month. If you make more than $1,350 a month, you're not disabled, no matter how disabled you are. So you can definitely work. Now, remember I was talking about SSI, you can always have more income if you're working part-time, even though your SSI is reduced. But the number I give out for parents to kind of ease your minds is that, like I said, explore working, have your son or daughter explore working as much as possible. But when they reach about $1,000 a month, that's when we should circle the wagons again and talk about whether or not there's other incentives that might apply to reduce the effects of income and just to kind of see where they're going. But it takes a lot of income, first of all, to lose your medical benefits. So that's something that often people will worry. Well, what happens if I lose my SSI? Well, I'll lose my Medicaid. No, there's other work incentives that apply. You have to be making more than 34,000 a year to lose your Medicaid in those circumstances. So, yes, short answer to the question is that your son or daughter can work part-time and get SSI. If your son or daughter, so this question is, my child's SSI was reduced by a third, even though she is still in school. For children, the rules are different. When we're talking about charging rent, we're talking about when your child is an adult over the age of 18. And if they're not getting their full benefit as a child, when they turn 18, you should be contacting Social Security Administration and letting them know that you're going to be charging them rent, and they should increase the amount of their benefit. Just to clarify, does my child need to be 18 to set up a power of attorney or medical directive? The answer is yes. To have the legal capacity to sign it, they have to be over the age of 18. Now, we can have it set up prior to that, but to sign it, every time I've had a young man or woman sign one, I notarize their signatures. We do it after they've turned 18. Another question on charging. So I talked about my flat fee for guardianship. It's $1,000. Flat fee for a power of attorney is $150. That's a durable general power of attorney. For an advanced directive, it's $75, and for a power of attorney for education, it's $75. All those are on the website, so you don't have to write that down.
Matt, I think another way to look at that too is they might have been asking how much should a parent charge for rent?
Oh, good. Oh, yes, that's a better question. So remember I said fair shares, what the Social Security Administration calls it. To get to the number, you add up all your housing expenses. Mortgage or rent, electric, gas, water, sewer, if you're paying it, plus food for the month. And you want to take averages over the year, because obviously some utilities would be higher in the winter and summer and so forth. But add those up, divide by the number of people living in your home, and that's technically your son or daughter's fair share and what you should be charging them. So the Social Security Administration will not balk at a number that's between 500 and even 750 if that's what the numbers come out to. And you do sometimes run into an issue if it's over 841, if it's over the SSI benefit, because then they'll tell you, well, since your son or daughter can't pay their fair share, they can't get the full benefit because that's a really sucky situation to be in, and there's not much I can do to help you. I'm going to get on my soapbox here for a little bit, but our government spends a lot of money on subsidizing other industries and doing things, and a lot of those things don't come with all the strings that are attached to paying a disability benefit every month to a young man or a woman with a disability who really needs it. They have all these things like charging them rent and $2,000 accountable resource limit. Your income is going to reduce it, and so this is one rule I wish would go away. But the way you figure it out is add up your expenses, divide by the number of people living in the house, and that's technically your son or daughter's fair share. Now, there's an art, I think, to working with the Social Security Administration at that point. And my advice would be to give them whatever they ask for all the time. Give them whatever they ask for, but only give them what they ask for. Don't volunteer any information. So if you say, I'm going to be charging them $700 in rent, and they say, okay, and they change the system, don't go into explaining how you got the number. But if they ask you how you got the number, it's like, well, I added all those things up. I talked to the attorney, said, yeah, I add up my, housing expenses and food for the month, divided by the number of people. And if they change the system, then don't give them your mortgage statement. So just give them what they want, but only what they ask for. don't volunteer information. This question is what happens if son or daughter have waiver for life? Will they have Medicaid or Medicare? Not exactly sure what that's question. If it's talking about Medicaid waiver for life, I don't think that that's possible. Medicaid waiver services would be continuously reevaluated as to whether or not they are still eligible for it. Can't think of any situations where somebody has come off the waiver, receiving a waiver though, because if they're that disabled to qualify it from the first place, for the young men and women that I work with, like with Down syndrome and autism and cerebral palsy and the number of gene deletion, they don't get to the point where they don't need their waiver services anymore. So they'll always have the Medicaid. Medicare comes in with, like I said, with the childhood disability benefit. I think all I would do is to reassure you that there are work incentives in place. There are incentives in place to allow a person to continue to maintain their Medicaid, Medicare, so forth. And if you have a particular concern, you should talk to somebody, either us or somebody who works with disability benefits. I was told that social services counts my resources until my child turns 22. Is this the same true for SSA? Not true for SSA. Your resources and parental deeming of income and assets ends when your son or daughter turns 18 for Social Security Administration purposes. There are various programs though through social services. There are Department of Aging and Rehabilitative Services, DARS, like Job Coach, and there's other requirements there though. So what proof is needed to deem your child as disabled? Wow. So the question, I am assuming, well, I answer it in a number of different ways. If it's for the Social Security Administration, the most important thing in an SSI or SSDI application is medical records. They'll want to see a diagnosis. That's just scratching the surface. They want to see long-term treatment. They want to see all the medications that were tried and didn't try. They want to see all the treatment, the therapies. And they'll take a look at that and then look at how your son or daughter's disability affects their ability to work. So there isn't any particular one thing. There isn't one thing. It's the mass of the medical records. It's statements from that you have the opportunity to put in the application. Sometimes it even could include statements from like a teacher or an opinion from a doctor. But all that goes in there, and think of it as a scale. The scale's got to get to a certain point, and you just keep putting more and more information onto the thing until you get to the point where the medical professional that's making the decision as to whether or not your son or daughter is disabled for SSI or SSDI is definitely whether or not they have a disability. More records, the better. If we're talking about for a court, it's much less. I write the petition, provide a medical report that checks off the boxes. It's an opinion from the doctor as whether or not your son or daughter needs a guardian. And I can tell you that whereas I will go sometimes out of my way to try to find the capacity for a young man or woman to find a power of attorney, sign a power of attorney or advance directive, doctors think a guardianship is often the way to go. So never had one come back and say no in any. And these are straightforward cases too. So, so for a guardianship, and it's the matter of getting the medical opinion from a doctor and the guardian ad litem, getting their input, and it's always the case where they say yes as well. So far in my experience, if a child begins to receive CDB, one will have to watch how much that is because depending on the amount, it could kick. Well, it won't kick you off of Medicaid or Medicaid waiver services. No, there's Medicaid. There's what it'll do is it require them to pay a portion of their benefits before their Medicaid and Medicaid waiver services. So you get into the, what is it, Medicaid, it's not buy-in, it's they don't lose their Medicaid waiver services and they don't lose their Medicaid. And they continue to get that even if their CDB and their earned income is past a certain level. They just have to pay for it. So, and in that case, can you turn down CDB? No, you can't. One of the requirements for SSI is that you apply for any other disability benefit that you may be eligible for. And when CDB becomes eligible, then in fact, most of the time, when a parent's retiring and they talk to me, I usually recommend that when they're working out their Social Security payment, that they also work out what their child's going to be doing, get it through the transition. If they don't, the Social Security Administration will eventually do it on their own. You get a letter saying that they're no longer eligible for their disability benefit. I wish they would be a little more specific because it freaks people out. And that they owe $3,000 for the last X amount of months. Then the next letter you get is, here's your new disability benefit and here's your check. So you can't turn it down because it's automatic. It's part of the, because SSI is meant to be payroll, also payroll or last resort. It's a type of welfare. Again, talking about all those petty, in my opinion, little requirements that the government puts on SSI is that if you're eligible for something else, then you have to get that. So we talked about Medicaid waivers. That has a $2,000 countable resource limit, and your son or daughter is a person with a disability, they maintain that Medicaid waiver. If they work enough so that they lose their SSI, which is possible, they still maintain their Medicaid and Medicaid waiver services. That's called being in 1619A status. That's a little too technical, but there's a work incentive that allows them to maintain those benefits. So we talked about how does this all affect waiver services? And the answer is it doesn't. The most it could do is that I do have clients that were receiving a childhood disability benefit. They end up having to pay a little bit every month. Copy of the PowerPoint? Yes, I think so. I think that you should be able to get it from FACT.
Yeah, we'll mail that out.
And they also have a copy of a handout that I usually work off of that has a little bit more information. So do you need to record any of these devices, trusts, guardianships publicly, like in the mortgage record, to put doctors and or the public on notice of the existence of the documents? No, we don't. The guardianship is a public record. Anybody who wants to get a copy of it could. I don't know why you would. They're not listed. It's not like you can go to a website for anything. You gotta know the case number and ask for it and pay for a copy. Powers of attorney, advance directives, you give a copy to the doctor. Copies work as well as the originals. They keep it on file. And after that, they'll never ask you again for a copy. Trusts, no, trusts are really not, well, the trust, if you create a trust, depending on the type of trust, it may have to be reported to the Social Security Administration and to the Department of Medical Assistance Services. But it's just, they're looking at it. They want to know that the asset's there, and then they'll review the trust to make sure it meets all the requirements. But otherwise, there's no real other way to record these for the public to put anybody else on notice. In a guardianship, can you elect to add a standby at a later time? Absolutely. You can add a standby guardian at any time. So with the understanding that our children are likely going to outlive us, when you do a guardianship, if you have somebody in mind that would be a great standby guardian at that time, my recommendation would be to add them. And later on, 10, 20 years later, assuming your son or daughter still needs a guardianship, and you're looking for a little bit more of somebody from a younger generation, so that you can have a kind of a sequence of protection of a guardian for your son or daughter, then you can add a standby guardian. If you think your son or daughter has the capacity, or I think a power of attorney advance directive would work, but you're really uncertain, is it better to go with the least restrictive? And I would say yes, it's easier. So is it possible if you decide a power of attorney and advance directive route and it's not working, then for whatever reason, can you do a guardianship? Is yes, absolutely. And in that guardianship petition, I would just have to give the court a copy of those documents and say, look, Your Honor, we tried the least restrictive route. It's not working. Here's why it's not working. We're not asking for any changes because we pointed the same. The parents are the agents under the documents. The parents want to be guardian. It's not like we're getting into, a fight between siblings for grandpa's money. And that's absolutely possible. The reverse is also true. If you decide your son or daughter, you want to lean towards a guardianship, and then you can restore rights down the road. That is probably a little bit more difficult. And my guess is that once it's in place, families will tend to just go with it because it's working and everything's all set up. And so you kind of lose a little bit of the desire to get rid of it. The other thing too is that when it comes to succession planning, I do have clients that come to me for guardianships or to talk about it because they're getting older and they've never done a guardianship. It used to be possible to get by to your son or daughter is like 45 or 50 on the power of, I am his mother. I've always made decisions for him. How dare you not let me? But they always run into an issue. And sometimes that issue is like, what happens when I pass? And at that point, we do a guardianship to get that succession in place. Accepting new clients, yes, but we're very busy. Contact information, website is www.BeneCounsel.com. It has some more information there and also has our flat fees. Does a standby have to be present in court during a guardianship hearing? No, just the, in fact, it's just the proposed guardians. The young man or woman doesn't have to be there. They can be there if they want to. But only in a few cases do they usually go, because usually all right, usually they'd rather go to school or day support wherever they're doing. I had one young man tell his parents he wanted to go, so they asked if it was okay, and it's like, yeah, of course. And he got there and he stayed in the car with his grandma, and he's like, I don't really want to go in there. I just wanted to get out of school. And I thought he was pretty smart. So, but no, they don't have to be there either.
Matt, that was wonderful. Thank you. Filled with lots of great information. We greatly appreciate your time. All righty. Bye. Bye, everyone.